essential stage in contract formation. I really barely think that needs to be said, because if we didn't have any say in whether we adopt the responsibilities set out in an offer, then you wouldn't be voluntarily entering the contract. You'd be being coerced into taking on obligations, and that would be an incredibly tyrannical contract law system. So, the law says we must accept offers for them to amount to anything. The laws surrounding acceptance also attempt to ensure there is clarity for both parties as to what they've assented to and when they've actually entered a contract. So, this is where we are right now in the series. I've made you an offer, and you aren't totally sure what to do. You want to accept the offer, but you aren't sure how. And just to clarify, you are the offeree, and I am the offeror. Acceptance is an unconditional agreement to the terms of the offer. Now, there are two main rules in acceptance. Firstly, the mirror image rule, where your acceptance must mirror the terms of the offer. And secondly, taking reasonable steps to let the offerer know you want to accept their offer. Simple. For instance, here is Gillian Reason accepting a job offer. It is unconditional, as she says she accepts all of the terms without any of her own conditions, and she is agreeing to the offer made to her and accepting all of his terms. All she needs to do now is post this acceptance letter and it is valid. Now, the mirror image rule means you have to agree to all the terms and not add any new terms or remove any terms. You merely assent to the terms of the offer. The terms you're accepting must mirror the terms of the offer. So, if I offer you these beautiful limited edition unicorn sports socks for £15 and you say, I accept your offer, you're accepting it in full. So this is a valid acceptance. But what if you said, I'll give you £5 for the socks? Well, this isn't acceptance. This is a new offer, as it doesn't match the terms of my offer. And interestingly, offering a counter-offer terminates my offer. So my offer no longer exists. I can, of course, accept your offer, or reject your offer, or offer you something else. I can even offer you the same offer that I've already offered you again. But my previous offer no longer stands. Because counter-offers terminate the original offer. The case of HYDE against Wrench is an example of this. Wrench offered to sell HYDE a farm for $1,000, and HYDE said he'd offer Wrench $950 for the farm. Wrench refused this. HYDE said he'd pay the full $1,000 and accept Wrench's original offer. But Wrench refused to allow HYDE to buy the farm for $1,000. HYDE took Wrench to court. He was appalled, but it was ruled that a counter-offer terminates the original offer. A counter-offer is not an unconditional acceptance to the terms of the offer, but a new offer, and when HYDE offered a lower price, that was deemed to be a refusal of the original offer. You might wonder why it would terminate the original offer, because surely there should be room for bargaining in contract law. Surely that's part of the foundations of contract law. But remember that offers usually come about after a period of negotiation between, particularly, businesses. It wouldn't be fair to force the offerer to keep their offer open whilst the other party is allowed to carry on negotiating for a better deal. Both parties can, of course, continue to negotiate until they agree on a new offer, but this means that the offerer isn't bound by his original offer. So a counter-offer is not an unconditional agreement to the terms of the offer, but a new offer, which the other party can accept or reject. Businesses often engage in a battle of counter-offers to try and get the deal agreed on their terms. So if A sends out an offer and you reply with your terms, then you're submitting a counter-offer. And this can go on for ages until one party gives in and agrees to the other party's terms. In Butler Machine Tool Co., one party offered a machine tool for £75,535 on his terms, quite a lot of money. Then the other party responded with a different quotation and without some of his terms. This response contained a tear-off slip at the bottom. So the seller sent this tariff slip, and he signed it. But he added in a letter which said he's delivering the tariff slip in accordance with his terms from before. Anyway, this went to court, and the courts decided that an offer was concluded on the buyer's terms. The seller had accepted the buyer's terms when he sent back the sign-off slip. The contents of the cover letter didn't change the fact that he'd accepted the buyer's offer. Clearly there's a lot at stake when engaging in a battle of the forms, so it was always important to read the terms you're agreeing to and to make sure that you know that your form is going to win. Okay, the second key rule of acceptance is that you must take all reasonable steps to communicate acceptance to the offeror. This is usually simple. You send the email, you post the letter, you tell them in person, and it ensures that the offeror knows that she's entered into a contract. Otherwise, how can she know that she's obligated to conform to her terms? How does she know that there's actually a contract? In general, acceptance isn't valid until it could reasonably have been known about. For instance, if you accepted my offer by email at midnight, and I worked in an office, then the acceptance would only take effect when office hours begin, say at 8 a.m, when I'm actually able to check my email. That's the general rule. However, the postal rule is the rule that when you post a letter only, you send, as acceptance, it is valid from the moment you post it rather than the moment it's received. So even if it gets lost in the post, the acceptance is valid and a contract has been formed. Now, Adams against Lindsell is the authority for the postal rule, and this concerned something to do with wool. So the postal rule might seem unfair, as it doesn't seem to make sense why post should have a different rule than email or telephone. But the offeror does have the right to specify how she wants the offer to be accepted. For instance, she can say, accept this offer by email only, and this mitigates the potential risk of using post. And posting the letter is all the offeree can reasonably do to submit her acceptance of the offer. So it isn't like she hasn't taken reasonable steps to make the offerer aware of the offer. In the modern day, the postal rule only applies where it is within the contemplation of both parties that according to the ordinary usage of mankind, the post might be used as a means of acceptance. For instance, in real estate, where quite often real estate is accepted through the post. The postal rule doesn't apply to instant communication because you usually know if your message has been delivered or not. Like when I send a WhatsApp message, I usually get a notification saying it hasn't been delivered. And it wouldn't be fair to detriment the offerer, who might not know about your acceptance, and there you are knowing full well that you've sent the message. You can accept an offer through any means, as long as, from an objective point of view, it is clear to a person in the position of the offerer that you have accepted the offer. Often the offerer will set out how he wants the acceptance to occur, for instance by saying, phone me back with your acceptance. You have to accept through that means. Although if there's an equally practical way of accepting the offer, then chances are this will still be considered a valid acceptance. It may be possible to accept an offer by conduct, but only where this clearly shows assent to the terms of the offer. For instance, in Nissan UK against Nissan Motor Manufacturing, Nissan started sending cars, which was deemed to be proof that they accepted the offer. However, you cannot accept an offer through silence. In the case of Feldhaus against Bindley, the claimant offered to buy his nephew's horse for £30 and said that, if I hear nothing from you, I'll assume the horse is mine. However, the courts ruled that this wasn't acceptance, that the nephew had not accepted anything. There are clear reasons for silence not being acceptance. Silence is usually ambiguous, and prohibiting this as a means of acceptance stops the offeree from accidentally accepting offers that he doesn't want. Now, the only offers you don't have to accept are reward-style offers, such as this one. Here, the offeree says he'll offer you £500 to whoever finds his dog and returns him safe. You don't have to agree to the offer, you just get the reward if you hand in the dog. Now, this type of offer is called a unilateral offer, and this is where you offer money if a specific performance is completed. They aren't directed towards one person, and only the offeror has any obligations, not the offeree. If you remember from the last video where the Carlil case was discussed, you didn't have to accept the offer, but merely catch the flu to claim the reward. This is only the case with unilateral offers, not bilateral exchanges, as we've been talking about earlier. Bilateral meaning concerning two parties. But hang on a second. What if you take so long to think about whether you want the socks that I no longer want to sell you them? What if I could get a better deal somewhere else for them? What rights do I have? We've been talking about you all this time, but what about me, the offerer? Well, as long as you haven't accepted the offer yet, I can withdraw it. And this is true at any point up until you accept it. Even if I've said that I'll keep my offer open for 12 days, I'm not legally bound by that promise and can still withdraw it before then. Offers can also be terminated when a reasonable amount of time has passed, and if the death of either party occurs, but only where this affects the offer. For instance, if I had offered to paint your portrait. So, we've learnt quite a lot about acceptance. Acceptance being an unequivocal agreement to the terms of the offer. We learnt about the mirror image rule, how you need to alert the offerer that you agree to his offer. We learnt about how when an offer is valid, and we learnt about the postal rule, and how silence is not acceptance, and how you can withdraw an offer before it is accepted. Thank you very much for watching, and I'll see you soon. Bye!